I will call us to order. First order of business today, we'll start with the Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Go ahead and say, I'll introduce myself and then I'll swear everybody in. I'll forget to swear them in now. For the respondents that are here today, my name is Drew Smith. I'm a practicing attorney. I am not an employee of the city. My role in these proceedings is to be an independent fact finder. The way each hearing will proceed today is the Code Enforcement Department will present, actually the first two cases, the Code Enforcement Department will present their facts and evidence. The Code Enforcement Officer will come and testify. When they are done, respondent will be given an opportunity to ask any questions you have of the Code Enforcement Officer related to your case and to present any evidence and testimony you would like me to receive. When I have received all the evidence and testimony, I'll enter a verbal ruling today. That will be followed in the mail by a written ruling that you will receive. The third case, actually, because that is an appeal or a motion for rehearing, really is how I'm going to characterize it. The appellant will go first on that. So the appellant will speak first, and then the city will have their opportunity. With that, clerk, you may call our first case. And before you do that, let me swear everybody in. Anybody who's going to give testimony today, if you'd rise for me and raise your right hand. Do you swear from the testimony you give today is the truth, the whole truth, and nothing but the truth? Thank you.
Case number 2021-1258, Milagros Rivera, owner, location of violation 1718 Charleston Lane, St. Cloud, Florida.
Good afternoon. Alex Miller, Code Enforcement Officer for the City of St. Cloud. I'm presenting the case for the property located at 1718 Charleston Lane. At this time, I would like to enter into evidence the following items: copy of the notices of violation sent by certified mail posted at the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted at the property in City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, copy of the sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $297.80. And the respondent is here. It was provided with the copies of On June 3rd, 2021, Code Enforcement received a complaint about this property having abandoned vehicles, high grass, and work being performed without a permit. Upon arrival, Supervisor Sparkman and I made contact with the owner and the handyman who were working at this location. I verified that there was a permit on record. However, due to the residents not being owner-occupied, it is required that a licensed contractor performs all the work according to the building codes. After speaking with the building official, the owner was advised to stop work until further notice, and a red tag stop order was placed on the dwelling. The owner was also advised about the other violations, and she stated that they will be corrected within 10 days. 2 photos were taken. On June 4th, a notice of violation by certified mail was sent to the owner to correct all the violations within 10 working days. Posted the property in City Hall, did an affidavit of posting, and 2 photos were taken. On June 16, I received a call stating the work was being performed at this location and verified that there was an active permit for this location. I made contact with the building official, and he stated that the owner will need to have all the work completed and obtain a final inspection within 90 days. I made contact with the owner and explained that the case will be placed on hold for 90 days. She understood. On September 14, Officer House and I met with the building official to obtain information on how to proceed with this case. We were advised that the permit had expired as of September 10, with no final inspections completed. Furthermore, it was stated that the structures will need to be removed from the property within 30 days. A notice of violation was sent by certified to the owner, intended to correct the violations. Posted the property in City Hall, did an affidavit of posting, and 12 photos were taken. On November 2nd, I verified that a new application for the addition was submitted to the building department, but was disapproved on 11/10 by building and 11/22 by planning and zoning. On November 23rd, it was verified that the property was still in violation, and a statement of violation and notice of hearing was sent by certified mail to the owner, posted the property in City Hall, did an affidavit of posting, and 2 photos were taken. As of December 13, I verified that the property is still in violation and the owner has been allowed ample time to come into compliance with the ongoing violation of having expired permits for this property. 2 photos were taken. It is the city's recommendation that the respondent be found in violation of allowing the permits to expire over 180 days, with work already started and no final inspection completed at this location by the time specified. The city will recommend that the respondent be given until January 7, 2022, to remove the structures, or a fine in the amount of $250 a day be assessed until compliance is met. The city also requests that the costs incurred in bringing this case before the magistrate in the amount of $297.80 to be paid within 7 days of the written order for the special magistrate. This concludes my presentation.
So in your request, you're asking that the structures be removed. Is there no possibility for getting permits for the work that's been performed?
I have the building official who can further explain what's going on with the case.
Thank you.
Hi, Robert Dethridge, Director of Building Department, Building Official for the City of St. Cloud. This has been going on since 2018. The owner of the property had applied for a permit to replace a mobile home. The zoning for the property allows a minimum of 700 square foot home. The home that she placed without an approved permit is 399 square feet. The previous community development director agreed to allow her to add an addition onto the home in order to bring it into compliance. This has been going on for 3 years. The addition that she brought in is really nothing more than a used shed. And in the pictures that you've seen, that's representative of the work that has been done since 2018. And I cannot issue a permit for this with it being in violation of the Land Development Code.
So in essence, there is nothing they could apply for a permit for that could be approved,
That is correct.
which is what puts the city in the position of asking for removal because there is no permit that can be approved. That's the city's position.
That is correct.
Okay. Anything else?
Not unless you have any more
That
questions.
answered my question. Thank you. Anything else from Code Enforcement Officer before I ask the respondent?
No, sir.
Respondent, you can come up.
Good afternoon. How you doing?
Good.
Good, thank you. My name is Ada
Last name?
Rivera. Rivera,
Rivera.
yes. I am Ada, and as my sister Milagros, she's the owner of the property. I am helping her. She's disabled, handicapped, and I am helping her to fulfill this land development. Back when originally the house was put in there, the 399 square footage, I have no idea. I've never ever owned a mobile home. I've never worked with anyone with the land development. I had contracted someone to pull out the permit. That person came in and pulled the permit. I have no idea that the home was too small. It was brought in there. I've done for my part everything I can during this last years to try to make sure that everything is in compliance. I know when I have gone more than 20, 30 times to the office down there, looking for answers, they told me that, yes, it could be approved if I add on extra living space, which I did. I've gone to an engineering to go in and look at the structures. I came back many times down to the office in the City Hall. I've spoken with, each of them on a few occasions about the structures, and the confusion because it's been a structure, not an actual mobile home, and the mobile home being already there. It's like, as you saw in the picture, there's a small 399 square footage mobile home, and then there is the building, a shed. I had tried to get the permit for all of this, which I did, and I have come back, and every time, everyone in the office had the same confusion. I tried to be in compliance. I had asked Mr. Deatherage if I could bring in the structure once, I was kind of given a permit. I wanted to make sure that they guarantee that if I brought the permit, if I brought the building structure, that I didn't have to remove it, because it took a lot of scheduling, during the pandemic to try to get that happen. I lost a family member through the pandemic. And, it was very difficult. I did not want to remove the structure once it was there, because we wanted to see, we want to be in compliance. We wanted to see it done. And this is where we are. I had contractor who's handling everything since, the last violation that they gave me. They gave me 180 days. I had the contractor who was working on it. We got all the materials, we got everything, we started the work, and he has been handling. I know that he said to me that he was required to submit certain documentation, which he did. And that's what we're waiting. We stopped the work because they put up red ticket on the door that we can't continue. So, honest to God, would like to see it finished. We're ready. We've been ready. It's just so many things, so many confusion going down the road, and this is where we are. We're not doing it because we don't have it finished because of us not wanting to. We're making it difficult. It's just things.
Has it been going on since 2018?
Yes.
I've been doing this for 20 years. A project that started in 2018 doesn't stop if the person who's doing the project wants to finish it.
Well,
timely. I know other things happen in life, but this is not, a project does not get delayed that long because a city delays it that long. And the 180 days is not a creation of the city, that is part of Florida Building Code. And it's not just 180 days that you have to finish. Actually, when you're progressing and calling in for inspections, that re-triggers the 180 days. So when I see a case where a permit has expired, that says to me that the person who had that permit has not done what they were supposed to do.
May I allow to say something?
Please do.
Okay. In the course of, getting to where we are right now, like I said, the pandemic, waiting on them, it's, while they don't give us any answer, we can't do any work. I don't want to be in any violation anymore and any more problems that, what it really is. Because things weren't happening, that's why I hired a contractor. And let me tell you, the first original contractor I hired, I was told that, I needed to have a fence in the property, even if nothing was finished. I tried to pull out a permit, pay for the permit. Half an hour after the permit was issued to me or granted, I got a call saying that, no, we can't do it because I don't have a final. Well, me having a final, don't know if it was for already the structure in there or a final is meaning completing the whole structure. The mobile home with the addition on it completed. So there's been a lot of confusion. That didn't happen. They put a stop, not because I failed to do it, it's just because there wasn't a final. So, and here's the situation. The final meaning the final on that mobile home, or is it as a whole unit, the mobile home with the structure as a whole unit. So there's been a lot of confusion. No one in the building was able to really clarify that.
Have you changed contractors?
Yes. I have a new contractor.
When did the new contractor come on?
Around September, a little before September. And so he's working, he's got all the documents, he registered, he got all the materials, everything is there. We're just waiting to get the green light, your authorization, they're okay, so we can complete it.
I understand that, but the problem that exists because the permit has expired.
Well, before this 180-day expire, we were interrupted. Oh,
How were you interrupted? That's what I have not, I
The
have not-
violations, they told us to stop the work order, posted on, red tickets.
Can I get you to step to the side 1 second? I'm going to ask the code enforcement officer a question.
Sure.
So the stop work orders, were those issued while the permit was still active or after the permit expired?
After the permit expires. So the first time when we received a complaint, I went to the property and because she was doing the work, it was placed a red tag, a red stop work order on the property. However, after she arranged everything with the building department, she was allowed to keep the work. And it was explained to the owner that she had 90 days from the date of whatever was given from the building department to complete the work and obtain a final inspection. So during that time, from
So let me go back to my question
Yes.
before. The first red tag was during or after the active period of the permit? Had the permit expired when the red tag was issued?
the first one, no, on June 3rd, no, sir.
The permit was still active?
The permit was still active.
And tell me again what the reason for the red tag was on June 3rd.
On June 3rd, because when we came to the location after the complaint was received, we found that she was doing the work herself with the handyman, which on the
It
permit.
was not the contractor who
Correct.
pulled the permit?
Correct.
Okay. Okay, that
And-
answers my question.
Yes, sir.
Now you
And
have
then-
responded back.
And then I just also wanted to add that during this time, I was working with the building department and have spoken with Milagros several times and explained to her what was going on with the permit. So it was explained to her clearly what the process was for the application and for not the permit to not expire, even after when I was in code enforcement and I've been to the property several times.
So now I understand, do you understand what she was saying there? The reason it was red tagged on June 3rd was because the contractor who had pulled the permit was not the person who was doing the work.
We were there doing cleanup, you do maintenance on the property, inside the building, outside.
Was the contractor doing the construction work that the permit was for?
Yes, and he was also doing, he had mentioned to me that he was required to submit certain documentation, and he was working on it during that time, way before the permit expired.
Why did you change contractors?
Because I thought that, since it obviously looked like, I didn't complete the work on time, maybe the contractor will be able to understand the situation, because the too much going back and forth, them having all the confusion down in here in the city hall. I guess it's the first time that someone brings a structure or a shed and wants to convey that into a living space, and the mobile home, and, that's the reason. I wanted to get the work done fast within that time, but, it was all the documentation that I'm not a contractor, so I don't know really what was required, but I did have the contractor. Prior than this contractor that submitted his paperwork and everything, I had another one that was going to take on the work. Unfortunately, that contractor was in an accident and was in the hospital for a month and a half. So
That's your prior contractor?
that was the previous one, but we weren't really, he was submitting the paper, we were in dealing with the actual, contract going on and to take effect. But it didn't happen because he was in an accident. It was
Is the
not.
reason for changing contractors because he was in an accident, or was the reason for changing contractors because he wasn't getting the work done that you wanted him to get done?
No, he never even got his hand onto work. The first,
But wait, you just told me he was doing the work and you were just cleaning up.
no, that's the contractor within this last 180 days.
So we have the current contractor and the prior contractor.
I checked and, okay, let me explain myself. During that 180 days, I had gotten a contractor to come in and put the paperwork so that, we can work and get this done and accomplished, in a rush.
Was
within
that
100
contractor going to do the work?
He was going to, but he got into an accident, so he never even got started.
So, wait, because I was trying to understand the June 3rd red tag, and I was explaining to you that they had red tagged it because the contractor who pulled the permit has to be the person doing the work. And you told me he was. Now
Okay.
you're telling me he wasn't.
No, okay. When I had that red tag.
I need you to be honest with me.
Being honest, and I can bring you all the evidence you need to.
Well,
Honest to
this
God.
is the opportunity. If you have the evidence, now's the time to show me.
I can probably make a phone call and see if that contractor that I was going to hire to do the work, maybe perhaps he can tell you, what had happened.
Is he here?
No, he's not, but maybe I can get him on the phone.
I'm not going to take his testimony over the phone.
Okay.
I will hear any witness that is here to testify.
But the contractor that I hire after him within the 180 days, his name is Hector Barrios.
But this conversation started because you said they were holding you up
Yes.
because of the red tag.
Right.
So I asked code enforcement, why was it red tagged? They said because the contractor who submitted the application was not the person doing the
That's
work.
the actual contractor who started working with the case. He started working.
That's a Florida, but, so my point is, and why this was important to me, is they had every right to red tag it if the contractor who pulled the permit was not the one doing the work.
He was there. He was there. He's
You
been
just
doing the
told me
work.
he was not because he was in an accident.
No, not that one. What I'm trying to tell you is, I tried every effort to get a contractor because they were saying I needed a contractor. I hire a first contractor. Didn't even last a week because he didn't even start it. We were just talking about the problem, the situation. He came in. he
So
spoke
no
with me.
permits have been pulled with this one.
No, he
Let's
didn't pull
go,
one.
get to the contractor that pulled permits. Let's
Okay.
start there. Who pulled permits?
Vista contractor. Vista contractor, and the name is Hector Barrios.
Okay, Hector Barrios pulled the permits.
Yes,
Okay. And so now your 180 days starts when those permits are pulled.
yes.
What work begins?
Work began.
What work begins?
What work?
Mm-hmm.
Okay. The insulation, the floor,
Who is doing that work?
the Hector.
Okay. Is Hector the one who was in an accident?
No,
Okay.
no. I'm sorry for confusing you, but what I'm trying to tell you is, what I've done for my part. The first person I hired did not even make it. You know-
Understood. This happens all the time. I deal with code enforcement cases in a lot of different places.
Mm-hmm.
And lots of times it is because of contractors not doing what contractors should do.
Okay.
Unfortunately, it's the property owner that gets pulled into code enforcement because you are the one ultimately who's
Right,
responsible
right.
for the property, and the property owner is the one who's responsible for what those contractors are doing.
Right, but the contractor started the work, got all the materials, like I said, started doing, the floors, the, whatever goes on the floor, the tiers,
So
the
this work that
installation.
starts, where does this fall in relation to June 3rd?
June 3rd. June 3rd?
That's the date of the red tag, which is what you'd said.
No, that was after, June 3rd,
So all the work you're telling me is happening now is happening after the red tag?
no, within the 180 days that they gave me here to work.
Right, and then the red tag, the first red tag fell within the 180 days. I'm trying to put together a timeline in my head, and the different contractors and who was doing what, because if there's any credibility to you saying it's because of the city that you were delayed, I want to take that into account. But right now, I'm not hearing a clear explanation of that.
Right, well, yes. After June 3rd, when they gave me, they were coming in saying, they stopped the work. They stopped the work saying, the violations, and they listed violations, the high, grass,
Well, that was separate from the red tag. The high grass, the disabled vehicles, that had nothing to do with the red tag. The red tag was about the contractor work being done.
Okay. Well, I know they stopped it twice, okay? So, and we couldn't do anything. Basically, I'm just waiting on the contractor who's been handling everything. He said, if they put the red tag in there, there's nothing we can do. We just have to stop until, things get clarified and we get, the authorization from you all. But I can tell you, they started the work, the materials are there, everything is just waiting, for us to, to give us, the authorization to continue and finish it.
Okay. Well, from my standpoint, the problem is you have a permit that's expired. And there's only two ways of solving that problem, and that is to remove what's there, what's been done without a permit, or to get an active permit. And I know the city has requested that I tell them to remove. That may be the only solution. Based on what I'm hearing today, I'm not willing to rule that. I'm not willing to say that they have to remove it. I will order that you have to cure it. And if there is no way of getting a permit, that means you are going to have to cure it. But that getting a permit, and I'm not telling you you're going to be able to. It's not, I can't tell the city any more than I can tell you how to cure a violation. I can't tell the city how they have to let you cure a violation.
I understand.
So your contractor is going to have to work with the city to see if there's any possible solution. And if there is not, you are going to have to remove it because you are going to have to come into compliance. You understand? City has asked for January 7th for a compliance date. This time of year and with what's going on, too soon. So I am going to give until January 31st to cure. That gives your contractor a little bit of time to see if there is any possibility. But again, I'm not telling you that there's a possibility here. I'm just saying I'm going to order you to cure it, and it's on you to get it cured. And if city says we can't issue a permit, you're going to have to figure out how to cure it. Okay? I will also order the respondent to pay the administrative costs in the amount of $297.80. I'm going to go ahead and put that on January 31st, too, for the timing of that. Yes, ma'am?
Just one more question. I just want to make sure that she also understands that she cannot be doing the work because many times we have been there. She is always working with the handyman and actually have moved the handyman into the property without even permission, and she was told that she cannot do that. So she's not following instructions, and I mean, I have explained it to her in Spanish and English, and
Okay.
creates a confusion.
Finishing up my ruling, if the property is not brought into compliance by January 31st, 2022, a fine of $250 a day shall accrue until it's brought into compliance. So what the code enforcement officer was just saying, and it's not part of the violation today, so it's not part of my ruling, but it is part of the law. It's Florida Building Code. It is part of state law that the contractor has to do the work. You cannot have a contractor pull a permit and then you be the one doing the work. It can't be you can't have a contractor pull a permit and then a handyman.
Am
do
I
it.
allowing the property, the cleaning, doing the landscaping, the cleaning,
No,
the
you
breaking?
you can mow the yard, you can clean. You cannot be involved in that construction work. And if you are, you're going to have more code enforcement problems, and you don't want that. So if there is, and I don't know, again, not really part of this case, but I'm trying to help you stay out of problems.
Thank you.
If part of this arrangement with the contractor is, if you'll just pull the permits for us, we'll do the work, that is illegal. Okay?
Thank you.
You'll get a ruling, written ruling in the mail, like I said at the beginning of the proceedings.
Thank you.
Okay, thank you.
Case number 2021-1683, Victor Carlos Colon and Lourdes Milerva Colon, owner, location of violation 3806 Cabo Rojo, St. Cloud, Florida.
Alex Miller with the City of St. Cloud, Code Enforcement Officer. I'm presenting the case for the property located at 3806 Cabo Rojo Drive. At this time, I would like to enter into evidence the following items: copy of the courtesy notice sent by regular mail, copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail, copy of the notice of violation sent by regular mail posted at the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted at the property in City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, copy of the section in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds a respondent in violation in the amount of $265.90. And the respondent is here, and I provided with the documents to him as well. On July 26, 2021. Sorry.
Binder?
Oh,
The evidence binder? Thank you.
On July 26, 2021, after receiving complaints on other properties that had placed obstructions in the right-of-way at this subdivision, I was made aware that this property had a tree in the right-of-way, and after verifying the complaint, it was determined that the property was in violation of the city codes. I made contact with Mr. Colon, the owner, to inform him about the violation, and he stated that he was given authorization by the HOA to plant the tree in the right-of-way. I explained that by the city code, he is not allowed to plant anything in the right-of-way, and that he can move the tree to his front yard. A courtesy notice by regular mail was sent to the owners to correct the violation, which within 10 days. Mr. Colon made contact with Supervisor Sparkman, requesting time to obtain the permit from the city to keep the tree in the right-of-way, and an extension was granted. On September 13, a reinspection was performed and verified that no permit was obtained, and the obstruction was not removed from the property, and the property was still in violation. On September 14, a notice of violation by regular mail was sent to the owners to correct the violation within 10 days. On October 12, a reinspection was performed and verified that no permit has been obtained, and the obstruction was not removed from the property, and the property was still in violation. A notice of violation by certified mail was sent to the owners to correct the violation. On November 1st, Officer House made contact with Mr. Colon to inform him about the continuance of the case because he has not removed the tree. Mr. Colon stated that he will not be removing the tree from the right-of-way. An email from the engineer and the permit was received with a copy of the disapproved permit application of Mr. Colon. On November 2nd, Mr. Colon requested a copy of the disapproved application, and all the paperwork was delivered to Mr. Colon's residence. On November 3rd, a notice of violation by regular mail was sent to the owners to correct the violation, posted the property in City Hall, did an affidavit of posting, and 2 photos were taken. On November 17, I verified that the property was still in violation, and 1 photo was taken. On November 18, a statement of violation and notice of hearing was sent by certified mail to the owners, posted the property in City Hall, did an affidavit of posting, and 2 photos were taken. On December 13, I verified that the tree has not been removed and the property is still in violation. It is the city's recommendation that the respondent be found in violation of allowing an obstruction to be placed within the right-of-way prior to city staff approval at this location by the time specified. The city will recommend that the respondent be given until December 31st, 2021 to remove the tree, or a fine in the amount of $100 a day be assessed until compliance is met. The city will also request the cost incurred in bringing this case before the magistrate in the amount of $265.90 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation.
The application for the permit to have the tree in the right-of-way, it was denied. You testified, correct?
Yes, sir.
Are you familiar with the reason why it was denied?
The engineer and the permit is here to answer that
That would be
question,
helpful,
sir.
thank you.
Hello, Don Callan, Engineering. We received the application, and city engineer wasn't allow us to issue any permits for additional trees in the right-of-way.
So it doesn't matter, it wasn't anything in particular to this property, nowhere in the city
Any
would this
trees.
permit have been, would this permit have been approved?
Correct.
Okay, thank you. Anything else?
No, sir.
Okay.
The respondent is here.
Respondent?
Hello, good afternoon. Victor Colon, I'm the owner of the property.
Okay.
And first off, everybody's been very nice to me this whole time, so that was surprising. I moved into Whaley's Creek in November 2019. Soon after, that's in St. Cloud. I put in for some modifications to my home, make some improvements. And then one of them was requesting to add a tree in the easement between the sidewalk and the street, a Crepe Myrtle tree. Got the paperwork back from the HOA. They checked with the developers. I was given the approval. I put the tree up. Then, in July of 2020, I received a letter from code enforcement saying that I was in violation of 38.1 right-of-way obstruction. And that's what the letter says. I'm sure you have copies there. So I figured, what does that mean? So I went into the city codes and I read 38.1, and it's an ordinance to protect sidewalks, to protect the ability to use a sidewalk. So I thought, okay, that's good. That's important. But what this tree is doing is not prohibiting the use of the sidewalk. So I then figured out I need to find out what's a right-of-way. So I looked in the code enforcement in St. Cloud, and I found street trees and planting within right-of-way, 85.8.5.11. I read that. It's a whole section of how you can plant trees, where you can plant them, how far they have to be in the right-of-ways, parking, the whole explanation in the city of St. Cloud. So, not understanding why I got this letter, because I didn't see where there was a violation as far as obstructing a sidewalk, or that I was in violation of the code for St. Cloud, I drove over and I spoke to these young ladies, and I said, hey, look, I have my HOA approval, this is my pictures, I'm following the rules, I don't break rules. On the contrary, why did this happen? So then they explained, well, there's somebody in your neighborhood that had many trees obstructing that could obstruct the sidewalk. That's fine for him. Didn't have the HOA approvals, which I did. I'm not doing those things.
And just
So-
to be clear, I could care less about HOA approvals. What the HOA says is okay has no bearing on what the city says.
I'll get to that.
What the city says is okay has no
Yeah.
bearing on what the HOA says.
All right. But, so then I said, the next question to them was, what do I need to do? Since obviously my HOA approval doesn't matter. So they said, well, you need to go to the Development Zoning Department. Contact Zoning Development Department, went over the, or to the person that they gave me. This is the problem, this is the issue. They said, no, your development has already been approved. You have to go to Public Works. So I go to Public Works and I speak to them over there. Everybody's still being very nice. I find somebody that's kind of figuring out, what do I need to do to plant a tree in the easement? They finally give me a form called
You can call it a right-of-way. It is a right-of-way.
right-of-way easement. That's what the code says. So they give me a form and I fill it out, like the gentleman said. And some time passes, I get it back. And I don't know if he's the one that called me or the engineer called me and said, we talked about this, and again, there's confusion. What is this? Why are we don't get these kind of permits? So then, when he asked me that, and then he said that he's gonna go back to his engineer to find out, I said, then if you don't get them, why are you denying them? I go back into the code, and I try to find, where do I need a permit? What is it that I need to do? You need a permit to take trees out, not to put them in, according to your code, that code that I just told you.
Do you have a copy of that with you?
I do.
Can I, if you have a copy, is there a copy I can keep?
You can keep, sure.
Because I can pull it up myself if I
Yeah,
need to.
38.
But if
right
you have
here.
a copy there, I'll use yours.
This is the planting of trees.
Thank you.
in the right of way. So then I get it back when they brought it to my house. They gave me the copy finally, and I see that it's denied. And I look at the form again. I'm like, what? How could? And the top of the form it says, underground utility permit. I don't need an underground utility permit. I have a tree that in what you're holding is an approved tree. It's a single tree in front of my home, not an underground utility permit. I don't, and that's what's denied. So, recapping, I know you guys, everybody's here is busy. Let me get my last three things here. The initial letter says I have a violation. There's no violation in the record in your code, 38.1, which I have here as well. Zoning department says, you're okay, your development's already been established. I go to St. Cloud's Utilities, they deny an application for an underground permit. I don't need an underground permit. I just want to have my tree. The last conversation I had with the young ladies over here, I was told that if the city allows for a tree, can I show you the tree? Or you saw it
I have
there,
a
right?
picture.
Okay.
I saw a picture of the tree.
In an easement, that the city would be liable for maintaining that tree. And that's why that they don't have permits for that tree. And I said, look, I've been living here since 2015. The other community had trees. We take care of our trees. Even though the HOA doesn't have standing here, their authorization for that tree tells me I have to maintain that tree.
Again, what's between you and the HOA has no bearing on the city. So the fact that the HOA told you, and actually what the city is telling you is somewhat accurate. You may be willing to take care of that tree, but it is, if it's in the right of way, it is the city's problem.
Understood.
And whether you move out one day, that tree is the city's problem.
But
So what they're telling you is accurate.
Understood, sir. So at the same time, is that that's when you have an obstruction. Right now, there's no obstruction. Right now, you have somebody beautifying their home with a single approved crepe myrtle tree, which is in your code. That's one of the trees that's allowed in your code.
And I reviewed 8.5-11, and I understood something you said earlier that didn't register with me, and now it does. When you were told, but your development is already built, that's probably, it was in response to your reference to this code section. This code section tells somebody who's developing property how they have to install trees. It is not for me as a property owner of a developed property to go in and say, oh, this is how I put in trees. This is a minimum standard for how developers put in trees. That's what this is regarding. There's a part of what you've argued today that I am going to follow up with the city on, but 8.5-11, I do not find persuasive to you.
And 38.1 says that I'm
And that's
instructing,
the part that I'm going to follow up with the city
but
on.
I have a couple more points.
Okay, go ahead.
One is there a permit from the city to allow a single crepe myrtle tree to be planted in front of a home? No. So they're asking me for something that doesn't exist. It's impossible to do. There is the code for obstruction, which is what instigated this. So therefore, they're asking me for something that's impossible to do. The reason why they came out is because somebody was obstructing the sidewalk with a bunch of trees, so I understand that. I'm not trying to do anything illegal. I follow the law. But when you have
What makes your case different than that case?
because I went with the approval first from the HOA.
Nope,
I
HOA
know.
approval has no bearing
But
here.
I
You
follow
can
the rules
stop
number
using
one.
it.
I follow the rules number one. I tried to get them to tell me what I needed. I went to both of those offices. They cannot help me. They don't have the ability to give the permit to be able to do it. They don't have it.
So if there is something that, take it out of City of St. Cloud, let's say it's City of Orlando. City of Orlando does not allow trees in the right of way.
But this
Period.
city does. You have a whole section about it.
We allow developers, and in fact, they probably require developers to put in street trees. That is different than allowing property owners to put in trees. Because, and there's a reason for that. When a developer is developing property, the developer is going through a very long process with the city, hearing after hearing after hearing, site plans, landscape plans, and then they have to follow those things. There are layers of review. When it's
Understood.
a private property owner who has purchased developed property, there is no layer of review for what's happening. So, and that's why I asked the question, what is the difference between 1 tree and 20 trees?
What is the difference between a gated community and an ungated community?
How
She's
it's
laughing,
developed.
but she's the one that asked, but they're the ones that told me. The difference from a gated, one of you just laughed.
Oh, I don't know, I laughed.
Okay, so, because when I spoke to the code enforcement, they said if your community was gated, it wouldn't matter what you have in the easement.
And they're telling you, what they're telling you is right, because if your community was gated, those would be private roads, not city right-of-way.
Okay, so that was my question to them. So, but at the same time, when they said that the maintenance of the tree, it's my responsibility.
And if you were in a gated community, it would be your problem, because it would be a
Well,
private road.
the
So
reason-
here's the thing. Earlier, I said you can stop calling it an easement, just call it right-of-way, because that's what it is. It
Yes,
is
sir.
the right-of-way.
Yes, sir.
Right-of-way is the city's right-of-way.
Yes, sir.
It's not your property.
Understood?
So why would I allow you to do something on property that you don't own?
Well, because that's what we've done in other communities here.
Where?
And Remington. And you have it,
Give me examples. I'm not trying to argue with you. I want to hear it. What,
would you just drive around?
so are you talking about private property owner of developed property has put trees into the right of way, or developer has
All I know
installed
is my
trees as part of
property.
required
I don't know.
development plans?
I don't know. But look, each step of this way, the answers that I've been given have not held water. From the violation, from the reasoning, and I'm not here to argue.
But I've been able to sit here without even hearing much from them as to the back and forth that's gone on from you, and understand exactly what you were being told before you told me what you were being told. So it makes sense to me what you've been being told.
The regulations didn't make sense.
I'm going to get there. I'm going to ask them
Okay,
that question.
that's what I mean, the
But
regulation.
I want you to give me an honest answer to the question I just asked.
What's that, sir?
Why would I tell them that you are allowed to put something on property that you don't own?
Well, that's why we're here, because I think that the answers that I've been given,
I'm asking you, why should I allow you to put something on property that you don't own?
well, my reasoning you're gonna say doesn't matter, because I got the permission from the HOA who checked with the developers.
That's right. That's
So-
not a good
so
answer to
then-
me. Do you have another one?
I don't, but I think that if you look at what I've done throughout this whole process, is trying, first off, and in the conversations, the way, every step of the way, the people understood, and they agreed with me. Even the young ladies here agreed with me about the tree. And that the codes are out. What's that?
No, I'm just saying if the city allowed it.
Yeah, but I spoke to you, and I spoke to you
And-
very nicely, and you both said, I know this is messed
We have
up,
to follow
we
the
should, the code is outdated. Everybody's told me the same thing.
And in any city in this state, any city in this country, you are going to run into those conversations because codes
But that's why we're here today,
get dated.
because I wasn't.
can't change the code, and that may be their problem or yours, but I still have the fundamental threshold problem that I'm struggling with of the right-of-way is the city's property. Theirs to control,
But
theirs
it's-
to maintain. If somebody trips and falls on the right-of-way, they get sued.
But this tree, or the city has codes for trees in the right of way. This tree.
That are about development, that are when
But that's not what
subdivisions
that
are being
says.
developed.
That doesn't say.
That is what this says. I've done this for 20 years.
All
You
right.
can trust me, that
Well,
is what this says.
Then I'll take your word for that. But there's rules for that. And I follow the rules for that tree and that property. And 38.1, there's no obstruction. Where are they gonna trip over that? They're gonna trip.
Okay,
It doesn't
and
make
that's,
sense.
that's the one that I have to hear from the city on, because
They're
I,
telling me I violated 38.1. I'm not obstructing anything. And I've done things the right way. If you tell me I gotta cut it down,
I'm just standing up to speak to the magistrate when you're done.
if you tell me I gotta cut it down, I'm gonna cut it down.
well,
But
I wouldn't like to see you cut it down. What I really want you to do is dig it up, because it's still small to be dug up, and move it 5 feet onto your own property where you have a right to plant things.
we'll have a cut down ceremony. We'll just cut it, if that's what you want. Because really, the principle of it is, I've done nothing wrong. I've tried to follow the rules.
Lots of code enforcement cases involve people who have tried to
Then-
follow the rules.
Then great, then, sir, you make the choice and I'll follow your rule.
Okay. So I do need to understand from the city where this violates the code section that's been cited.
Well, it's 38.1, and I have it right here. I don't have a copy of 8.511, but that's not at issue here. The 38.1, which was cited, was it states right here, it shall be unlawful to place any obstruction in on any public street or sidewalk, lane or alley, or make any excavation in any street or under any sidewalk until such person shall have first applied for and obtained from the city manager a permit for such purpose. So the end of that is no permit was obtained.
But
So-
is
so-
the tree in the sidewalk or street?
Well, it's in, the right-of-way is defined under the Land Development Code as land.
And that's where I'm struggling with this code section. That code section does not use the term right-of-way.
Well, use lane, all right? And again, it's implicit that if the city has a permitting privilege over land, it's going to be the public right-of-way or lane or alley or street. It's implicit within the code. It certainly isn't imposing any type of permit requirement on private property under this section.
No,
So-
and you've picked up where I'm struggling with this code section, because if it said it shall be unlawful to place any obstruction in a right-of-way, it's easy. But this says street, sidewalk, lane, or alley. So I need somebody to show me where this strip of grass is one of those things.
In the photographs of the tree.
No, or in the code, something that says the area we're talking about is doing what this code section says is not allowed.
Well, the right-of-way under Land Development Code is defined as land.
This code section does not use the term right-of-way.
Oh, I understand. But I'm using the Land Development Code's definition of it to tie into the language
Okay.
of the code. Right-of-way under the Land Development Code is land dedicated, deeded, used, or to be used for a street, boulevard, public utilities, drainage facility, or other purpose by the public, certain designated individuals or governing bodies. So, land used or to be used for a street or boulevard, okay, that can certainly tie into public street or sidewalk, lane or alley. I would think that those are synonymous. They're not necessarily identical, but they are synonymous. The intent, I think, is captured in the code.
Is the grassed area that the tree is planted being used as street or sidewalk? Or lane or alley?
I'll defer to that to the code inspector. Well,
No,
until we make our
I'm
point.
talking to the city right now.
Can I start off
Hold-
by
hold-
saying,
Hold on, let me, the magistrate has a question for the inspector.
okay, go ahead.
So could you ask the inspector that again, ma'am? Sorry.
Is where the tree is planted, in the grass strip between sidewalk and road, where the tree is planted, is that part of the public street, sidewalk, lane, or alley?
No, answer his question. Our position is it is.
Okay, and why? Whoever's going to give me the answer needs to be the one testifying to the answer.
Go for it. No, just go.
If there's a different code, I don't need to hear from the code enforcement officer in this case. Whatever code enforcement officer wants to give me the answer,
Okay, I'll answer that question. Yes, it is part of,
name and title for the record, please.
Melissa Howells, Code Enforcement Officer for the City of St. Cloud.
Okay, and now
Okay.
the answer?
Yes, it is. And the reason being is because we've had numerous properties that plant stuff in the right-of-way. That I know this gentleman
Not
says.
worried about what other
Okay.
properties have done. I
Okay.
want to hear why a grass strip is part of the public street, sidewalk, lane, or
Because
alley.
it can cause an obstruction.
No, I want to know, that's not the question I'm asking. Why is the grass strip part of the public street, sidewalk, lane, or alley?
I don't think it's because you can park there.
If I
Go ahead.
am a pedestrian walking along the sidewalk,
You can still walk on it.
if I am a pedestrian walking along the sidewalk, do I have a right to step onto the grass, a public right of ingress, egress, to step onto that grass and navigate that area?
Yes, you are.
So it is part of the public right-of-way associated to that pedestrian sidewalk?
Yes, it is.
If I am a vehicular driver and I'm driving down the road and I want to pull off of the road and park, do I have a right to put two wheels onto that grass?
Yes.
So it is part of the public right-of-way for the roadway.
Yes, it is. It can be. The only citations we would write is if you park across the sidewalk with a vehicle. And I have reasoning behind that too, because the city code does not address parking in the grass in the city of St. Cloud. HOAs do.
I'm not looking for reasoning or explanations of anything. I'm looking to see if this section applies. And the last two answers you gave me are the ones that I think are determinative to me in this case, because rights-of-way are just that. Whether they're paved or concreted over, a right-of-way is a right-of-way, and it is a right of access to the public.
Yes.
And so a sidewalk, the grassed area next to a sidewalk is still part of the function of that sidewalk. A roadway, the grass shoulder next to a roadway is still part of the function of that roadway.
Yes, it is.
And for that reason, I am going to find that this code section applies. And therefore, I am going to require that the tree be removed. I don't want to hear any more. You had your opportunity. You said you would do what I wanted. I'm telling you what I'm ordering.
I think you're wrong.
That's okay. You have every right to think I'm wrong.
You didn't allow me to, first off, she's not the person to answer the question about parking. And secondly, it says right here, permit. They told me that they're unable to issue permits because they don't exist. You have to have permits to destroy a sidewalk, not to plant trees in an easement.
There is nothing in this code section about planting trees.
Exactly, because that's not what it's for. That's for obstruction.
I disagree with you there, because, and I'll tell you another reason why or cities are very careful about where trees get planted, because trees push up sidewalks. But I will go beyond almost. I will guarantee you there is a permit for underground excavation. Some of the things that are discussed here, there is a permit for. And just this is the example I was trying to use with you for the city of Orlando. If the city of Orlando does not allow trees to be planted in rights-of-way, period, end of story, they will not have a permit for it because there is no reason to apply. So I do not find that argument persuasive here.
But part of the easement is where you had trouble, which is exactly the
And I did, and you heard me struggle with it, but I find that this is part of the sidewalk and roadway right-of-way, and therefore this code section is applicable. So I will order the respondent to remove the tree, order the tree to be removed by December 31st, 2021. If not removed by that date, a fine of $100 per day shall accrue until compliance is met. Also order the respondent to pay the administrative costs incurred by the city in prosecution of the case in the amount of $265.90. I'm going to make that date December 31st also.
Thank you, sir.
Unfinished business, case number 2021-640, Benjamin Estates HOA, Inc., owner, location of violation, Benjamin Estates, Tract B and C, Conservation and Buffer, St. Cloud, Florida.
Good afternoon again. I had requested the appeal on.
Name and
Oh, yes. My name
relationship to the
is
property for me.
Jennifer Conklin. I am the community manager for Benjamin Estates. I'm here on behalf of the Board of Directors. The Board of Directors had requested for me to submit an appeal upon further review of the work that was asked to be done to be in compliance. We had sent multiple communications with city engineering as well as code enforcement, which Melissa was very good to reach out. She was able to tell me there was really nothing she could do, that I did need to get with engineering. I've reached out to the city manager because the board was requesting some proper documentation on what was requested within the first violation. The first violation said that we had to get the swale over on track C to compliance, which, per the as-bills, which I do have the as-bills, and I can show this to you if you like. It does say that it requires a 1-foot deep environmental swale. Upon my contractor, or the board's contractor, when fixing the swale and putting it to compliance, had a couple meetings with Mr. Callahan, and they had put in some sticks and required it to be a 2-foot swale. So well over compliance of what the as-bills from what the violation was.
Is there a 1-foot deep swell there?
Oh, it's more than 1 foot now.
Okay.
Before that, I would say it was a little bit less than 1 foot. I do have a before picture of what it did look like. There was a swale. I can't, without measuring it, could say if it was a 1 foot, but it's well over 1 foot now. On top of that, we were requested by city engineering to install a pipe to run into the proper drainage area. Upon review of plats of the community, that was to run through tract D. And on the tract, which is recorded for the community, tract D is actually dedicated as a right-of-way to the city. So the board feels that if this was dedicated to the city, really it would have been, as you had said, city's responsibility to maintain.
Not necessarily,
Okay.
because I'm going to presume, again, just using my experience with
Right.
development, that the expectation was developer will put in the infrastructure and then it gets dedicated to the city.
Correct. The as-bills that were approved never required a pipe.
Okay.
So it was never required from the original plans. I do also have inspections here from Southwest Water Management District who approved them with the swale and the drainage when they were built. So that's where and we were looking for clarification. And we had written, and I have it in and that's why I did it in writing, documentation of requesting these documents showing that these new requirements were a requirement. Because the board's like, look, we want to be in compliance, we want to make sure we're doing it right, but to justify these extra costs on this very small community, which would be a big chunk out of each pocket, we need to have that documentation to justify it. We've never received anything more than what I have, and from what I've seen and being able to present to the board feels that we're well above where we need to be in compliance.
Okay.
And I do have.
So when I asked the question, is there a 1-foot deep swell, you said it's more than, so work has been done
Oh, yes.
since my order?
Oh, yeah.
Okay, what has been done since my order?
The full, I'll give these to you. I have.
Can I keep them?
Absolutely.
Jack, you want to look at them before she hands them to me?
Yeah, the first picture is the original picture from the.
I just want him to see in case he has any objection.
Yeah,
Yeah, I need us to look at them
sure.
too.
That's the original one from compliance.
Before, you mean you
Before
started
anything
anywhere?
done, I'll give that one to him. And then these are the pictures that were taken while we were finishing completion. The only thing that was left to be done was to sod, which has been completed. These were taken in October or November. The sod has been done, and I do have pictures from today showing that it was completed. And those were just pictures from next door
Yeah, you could
that
do
also
these
had
guys, but-
the RCP pipe.
Okay.
Thank you.
Wait till she's finished.
So do I understand your position today to be that we've done everything that we were required to do to come into compliance with my order, because my order required you to come into compliance with the site plan, and you are arguing that you have done that?
I feel we've done it, and we've done it in abundance to what the original violation was to put it into code from the original approved plans, which was a 1-foot swale, which, as you can see, is definitely over that because we were told by city engineering it needed to be 2 feet.
Do you have anything else right now? I'm going to have you, I'll give you an opportunity back at the podium, but I want to get into this with the cities. I wanna get their
Absolutely. I
side
will
of
give
the
you
story,
copies
too.
of this as well. This
That-
is just and I'll give this to you, it's off of the as-built plan, showing that it says a 1-foot deep
Okay.
environmental swale. And on that as well, you can see that there is nothing written in there that says a pipe or anything was required.
Let me explain.
Yeah, you will. You'll get a chance.
It's very simple.
I'll give it to you. That's fine.
And really, this case is mostly just to get the clarification, which we never received.
Anything else right now before I give the city an opportunity to
If you'd like the communications of the multiple communications
hold on to
asking
them
for
right
it.
now? Because I don't know that I'll have any really need to go through
I didn't think
those.
so, that's why, I didn't give them to you yet.
Hold on to them for now, but I will give you an opportunity back at the podium. So if you think that it's necessary to give that to me at some point, you'll have the opportunity. But I want to hear from them on, and city, what I want to hear at the moment is, I mean, you've heard their argument. What we've done brings us into compliance with what we were required to do by the site plan, by the as-built. So first thing I want to hear is, why is that not true? Or if it's true, that it is true.
Okay. Don Callahan, engineering again. The reason it went from 1 foot to 2 foot is that the original swale was only a foot deep, but someone filled that in. And when they filled that in, they raised the entire area. When we found the issue, we contacted the engineer of record that designed it and asked him for an elevation to leave that swale's sole purpose is to drain that wetland. So we asked him for an elevation of what to leave with that would have positive fall to get it to the system that it drains to. He provided that, and that was a stake she referred to. I set them grade on where to leave at, and because that whole area had been raised, now that 1 foot, what was 1 foot at one time, now is 2 feet. They want to regrade the whole area, they can take it back down and make it 1 foot. But the elevation is important to hold out that wetlands at a certain elevation whenever it's draining. Does
So
that
there
make
was
sense?
fill brought in.
Someone
to
filled
the
that in. We're not sure who filled it in. We discovered it when there was complaints on the wetland being high. We went and looked and we found that the swale was no longer there. Does that make sense?
It does.
Okay. Be it the HOA's responsibility. We contacted him immediately upon finding that the
I
problem.
understand that, but, and I'll just, again, just like I've done in the other cases today, I'm gonna put my cards out on the table. Here's where I'm struggling. Because the code violation that was brought forward and what I issued an order based on was their site plan required this. And my order was, you gotta comply with your site plan. So I think what I'm hearing engineering say is, well, in order to work effectively, it needs to be this. I don't have the power to enforce anything beyond what I ruled on and what was brought, which is they have to meet their site plan. And so if the issue is they brought in fill that violates the site plan, we need to address that issue. I don't know that I can say you have to do more than what that site plan required or something different than what that site plan required in order to fix this, because my ruling was based on the fact that site plan requires X, you have to do X.
Right. I'm not sure if it's been a while since I saw this plan. That plan may also have an elevation on it.
Yeah, I was just gonna
But that's
say
what it's
that.
based on. The elevation is important. It was permitted on the elevation, because what way the system works.
And what
the
you
pond-
mean by that, to translate, make sure I'm understanding it and everybody else is, if it has elevations in there, then we're not talking just this piece of evidence, which is
Right.
a drawing that says 1 foot deep. It would actually have where that 1 foot falls to.
Correct, correct. The reason the pipe was required is because at the time that swell was constructed, there was nothing there. There's now been a sidewalk placed, so you'll have to put a pipe across that sidewalk to allow that sidewalk to maintain connectivity. Being that sidewalk is in the right-of-way, and that pipe will then be in the right-of-way, it has to meet city code, so it was required to be a 15-inch RCP. That was communicated multiple times at the beginning, through the whole thing. What they placed.
Say that again. Explain that to me. Go through that one more
The
time.
original
for me.
swell just discharged to the then county ditch, it's now city ditch. Since this has been filled in, there's been a sidewalk placed. So that sidewalk, to make that swell connect to the drainage system, which is outside the sidewalk, it requires a pipe underneath to allow it to drain. Being as that pipe is going to be located in the right-of-way, it has to be a pipe, it would have to be installed to meet city codes, city standards, which is minimum 15 or equivalent. And it has to be RCP, it has to be concrete pipe.
So, from city's standpoint, in order for stormwater transmission to work appropriately, there has to be a pipe there, because otherwise there is a blockage in the system.
Correct, the sidewalk would block it.
Okay, let me get you to step aside and get the HOA representative up to see if,
Do you want a copy of this to see the tracks, remember?
I don't need it right now.
Actually, the as-built does have the sidewalks on the plan, and again, no pipe required.
Can I keep it?
Yeah.
So, you understand the significance of stormwater transmission.
Absolutely.
If there are sidewalks blocking the transmission, how does water get from this side of this, or this side to that side, driveways? This side
Correct,
to that side?
and I do understand that. The thing is that no one had brought in fill because we have the approvals from Southwest Water, which was part of the drainage facility. This swale was part of that, who approved it at the time of completion. So nothing was filled in, at least from the part of the HOA. I don't know if it was movement of, land, settling, if anything changed, but nothing, HOA did not fill anything in, and it was approved at the time when the drainage facilities were reviewed. So that's where the communication and the lack of information is where we're having issues with. Also, the sidewalk there, it had been constructed, easy enough, can be removed because it goes right into a conservation tract where nothing can be built.
Is there-
So,
To your knowledge, is there piping shown on any of this, as-built?
for the driveways, there is piping.
Under driveway?
Mm-hmm.
Yeah, I see it there. And where is the pipe at issue? Or the not pipe at issue?
No, it's a double corrugated pipe, almost as strong as the concrete. It is under ground right now. We had removed the sidewalk, and because it was just going into the conservation tract, so the sidewalk couldn't even be
So there
completed.
is a pipe, the issue is whether or not it meets city, the pipe that's there meets city
Well,
code.
and the question that the board had is, the pipe was never required per the as-bills, as you can see. It was the 1 foot swale. Now, we're being told the elevation changed, which, again, we were not given that information. Our vendor and our contractor literally got a stick in the ground saying, dig 24 inches. Because again, I'm not an engineer, and I'll be the first one to say that. So I was having our contractor, who was willing to work with city engineering to make sure it was being done to code. So now we have, like I said, a 2 to 3 foot swale, and if that's what makes us in compliance for the change of elevation, the question remaining is, are we now in compliance if we remove that sidewalk? Because again, then there's no sidewalk It's just ground going into a conservation tract that can't be built on anyway. It's preservation.
Well, if I let you set the side, we'll ask that question. So you've heard the city, you've heard the questions, and so I will ask that question, but also in terms of the swale, from city standpoint, two questions. What would city like to see done? And if that's different than what does city think has to be done, what's left to do here?
What the city would like to be compliant, the swale that they've constructed is fine. It's not tied into the wetland. They left a small piece, we assume, is to keep the water off of them until they're done working. That needs to be dug out so that it becomes operational, and then the pipe needs to be changed out to a pipe that meets city code.
If they remove the sidewalk, does the pipe still an issue?
If the sidewalk was not there and it does go in, it goes to, the right-of-way continues through that. It doesn't go through the conservation areas. There's a right-of-way all the way through there. But the houses being built down is not required to have sidewalks, so yes, it could be removed,
So
and yes, it could be graded.
The pipe that was there, that's the original pipe. I mean, that was installed with, is that new?
No, the pipe was installed new, and it's
New.
10-inch, it is 10-inch plastic is what's there now.
Okay.
Just so you know, we had a concrete pipe and we were going to put it in. But when they were gonna put it in, there were utility lines under the sidewalk, electrical and other utility lines, and they were not able to get a round concrete pipe through there. We had to go with the double corrugated to make sure we did not hit those utility lines.
So assuming the sidewalk is removed,
It is,
what's left for them to do from
It's been
city's?
removed because it was supposed to be put back, but it had never been put back. If the sidewalk was cut back, then they have to complete the swale to the driveway, or through the ditch, and then open up the other end to where it works.
Okay. HOA,
so just to be clear, so the sidewalk is removed, so we need to remove the pipe, just make it a full swale, and then finish it out to the pond.
I can't give that authority, because I'm not the city engineer, but I'll ask the city engineer, but I don't have that authority to change what he's asked to be done.
you're gonna need to have site visit by city to make sure whatever you do, I would do it before you do any more work.
Yeah.
To walk the property, say, if we do X, Y, and Z, are we good? And then do X, Y, and Z.
Absolutely, we've been asking for meetings, so.
The pipe, whether it's in the as-built or not, I mean, I'm going to, I guess, order this case abated for the time being while the city works this out, or the city and the HOA works this out. To the extent there were any fines running, I'm going to abate that also, so that nothing is running, because I think it sounds like the HOA has made a good faith effort to move forward and do something. There has been some dispute as to what is required. Based on the documentation and the history, I don't see any bad faith on behalf of the HOA in that. I don't know how the grade of that property came up, but short of somebody doing it without authorization,
Right.
it's hard for me to believe that the HOA had fill dirt brought into, what is a conservation tract. Unless somebody, somewhere along the road had fill dirt, they needed to find a place to put. It just doesn't make much sense to me. So I don't know how the grade came up on it, but it sounds like you've done what you needed to do to get to the right depth. Now it's just a matter of finishing the work. As for the pipe, even though it's not shown here, yeah, I think you recognize you need to fix the pipe issue. And if it's by removing the sidewalk, and it sounds like that will cure it by taking the sidewalk out, again, make sure that where you're cutting the sidewalk, how you're cutting the sidewalk is going to satisfy the city before you do it, and then do it and have them back out to make sure that they agree. But even though it's not here, if that pipe doesn't meet code, you're gonna have another code enforcement problem down the road if it's not
Understand.
today. So we might as well deal with that situation. But other than that, I'm gonna order this case abated. During the pendency of this, if we could put it on, do you think all this can be worked out by January, or do you think February? I'm looking to both city and respondent there.
What I'll do is get the city engineer in the morning and take him to site it. I'd love to have you meet us there, take a look at it.
Tomorrow morning, unfortunately, I already have another meeting, but,
He's out next week.
Well, and given notice requirements, put this on your agenda for February and notice it for February. If everything has been resolved, everybody is going their way happily, you can just come and report that to me. We don't have to have a full-blown hearing. If there's any dispute left, then let's finish this up in February. Okay?
okay, thank you very much.
Thank you.
I have your email, let me get him the one.
Next New business, none. Next scheduled meeting, January 19th, 2022.
Anything else from city? No, sir. Anything else from clerk? Nope. Well, everybody have a happy holiday. See you all in the new year.
Now,
We save the best one for last.
do we do these? Is this like 1, 2, and then 3? Because she gave it at 3 different times, or do I?